I'm certain that you may have followed the conversation about the lead counsel for the former Chief Justice and as well the former Auditor-General Daniel Domelevo. And we're joined by the lead counsel for the removed Chief Justice, Ayikoi Otoo, who's been lashing out at the former Auditor-General Domelevo, describing his act as shameful after Domelevo accused him in an interview that he produced fake documents to the committee sitting on the case of the former Chief Justice. But I've got that video for you. Let's watch and listen first. We get into it.
Now let's come to Mr. Ayikoi Otoo's attack on me. I find it very interesting. He said he has provided all the evidence to Mr. Domelevo, a former Auditor General. And I sat there and I didn't take it, and other people, I was whatever influenced my decision, he doesn't know. I want to put it on record that he provided us with evidence that were fake evidence. It will interest you to know that it is the junior of the Chief Justice, the Judicial Secretary, who appointed the Chief Justice.
How is that?
Yes, that letter he produced is signed by the Judicial Secretary appointing a Chief Justice. So if you follow the briefing that the Attorney General has been given, a lot of work is going on.
We're joined by lead counsel for the former Chief Justice. We're just seeking a bit of clarity. Good morning and thank you for joining us this morning. Yesterday I followed the conversation. One of my questions I'd like to ask you is that I watched that interview quite extensively with KSM and as well Domelevo yesterday. And one of the things that he said that caught my attention was that it looks as though one of the documents which you presented would be that the appointment of the Chief Justice came from the Secretary of the Judicial Service. While yesterday on the news with my colleagues, I also heard you say that it will be the benefits that the Chief Justice would have been enjoying after his appointment, her appointment, pardon me. Can I get clarity on what exactly the issue is?
Okay, thank you very much. That is why I describe him as very shameful and playing politics with the entire process. Now, this is Domelevo, who
That's an interesting statement.
Who is rated very highly as an Auditor General, and people were not happy when he was hounded out of office. And then such an individual comes on radio or television to tell us that he is not aware that whatever warrant is given to somebody will not contain the person's conditions of service. I brought in Domelevo in my discussions because of the position he had previously occupied as a former Auditor General. And therefore, we felt that once we were dealing with financial issues, it would be the best person to explain to the committee members what the position is. Now, there was an audit. There was an audit query, there was an explanation, and then finally what we call a management letter. In that audit query, they ask about the travels and the payment of per diem given to the lady as well as to the person who accompanied her, being the husband on one occasion and then the daughter on the other occasion. So they raise issue about that. Then the spending officer, who happens to be the Judicial Secretary, explains to them and brings out what she calls the travel policy and says, look, nothing wrong was done when we bought ticket and paid per diem, because these are the travel policies which had been agreed to and approved by the Judicial Council. She did nothing wrong. When the management letter came, those things were dropped completely from the management letter for that particular year. So how come that at the end of the hearing, we saw a report saying that she has still been held liable as being the head of the judiciary for traveling and for getting per diem given to herself and the persons that she traveled with. And that's why I faulted him. that you being the Auditor General, you know all these steps of audit query. When I said audit query, he even at the committee said no, it was rather an audit observation. He was the one who corrected and said, no, maybe an audit observation because we no longer call it audit query. And then we went through the response by the auditee. Then we came to the audit management letter, which did not raise this issue again. How could you have sat there and then gone to the meeting, a final meeting, to make recommendation to the president to say that she get herself involved in a stated misbehavior for what happened, and therefore she should be reprimanded and removed from office? Is she the spending officer? Okay. And it was this spending officer we tendered that letter to show that after she has been appointed, the spending officer gave her the letter showing her conditions of service.
This letter, which has become the contention as to whether it is fake or not, did it have the letterhead as coming from the judicial service, or it had a letterhead saying that it is an appointment letter? Because then I'm quite confused why Daniel Domelevo would say that that document is fake, and that's where my focus really is, without getting into all the other details. This particular letter, did it have the letterhead as appointment letter, or just conditions of services?
No, it would refer to your appointment. As for the appointment, it has already been done by the president.
Absolutely.
So it refers to your appointment and tells you that these are your conditions of service. And he is saying that seeing the appointment of a Chief Justice there means that she was rather the one who appointed the Chief Justice. Was it not in this country when the Chief Justice was appointed?
Was this brought to your attention at the sitting at all?
This is why everybody is surprised at what he's doing.
Was this brought to your attention? Was this brought to your attention at the sitting at all? And
surprised at this attitude that he has adopted. And I'm saying that it doesn't happen anywhere. Let me cite my two previous appointments to you. I was appointed the Minister of Justice and Attorney General. Then the secretary to the president writes to me on a green paper telling me these are your conditions of service. I was again appointed as High Commissioner to Canada. I had already been appointed by the president. Then they asked us to go for letters from the Ministry of Foreign Affairs. I said, why should I go there? Nobody is appointing me from there. They said, no, you have to go there because you are now considered as A1 officer working for the Ministry of Foreign Affairs. I went for the letter and it contains all my conditions of service. And that was never signed by the president. He ought to know.
Granted, he indicated in that interview that he's speaking on his behalf, he's not speaking on behalf of the committee.
No, I'm attacking him because of his position as a former Auditor General who goes about auditing people.
To what end then?
Sorry?
To what end would this be then? If he's just speaking, if he's just speaking on his behalf and then it's not the committee that he's speaking on his behalf, on their behalf, then, well, when we attack him, what end would this bring?
I said that I attacked him because I brought him into the discussion because they ignored these exhibits that we put before them. There is another one which talks about allowances, travel allowances for foreign people, foreign travel in the public services. And it was clearly stated that members of the judiciary and parliamentary service have been excluded. Applicable rates are to be approved by their councils. We also tendered this. They ignored. So he should not say that I said I gave evidence to him, not him as an individual. I'm talking about evidence that we produced before the committee, which were ignored. And we were expecting him, having regard to his former office, to rather bring some leverage, something to bear and to explain to his people, and not that he would turn around, divert attention, and now talk about fake letters. What is that?
That's quite damning, not just on the whole procedure, but as well you, as a former Attorney General. What do you intend doing? Especially he cited that it's fake.
Those questions, don't worry about that. I will advise myself. I know what to do. I mean, if I advise people, I should be able to advise myself.
I'm just curious
So
about the advice you'd give yourself.
I want him to live with his conscience until the day. If what he did, if he felt it was right to go and sit on me as a lawyer, how do I bring fake letters to support my client? If anything at all, it is my client who will produce the letters to me before I will tender them. So how do you zoom in on me? Because I had earlier attacked him, that he went and sat there and looked on when the people were doing wrong things. And we expected him to bring some conscience to bear on what was happening, having regard to his position.
Does it, and some education here, does it come to you as a surprise, knowing that this whole procedure is quite adversarial? The committee sitting down, does it form part of the investigative process where they can just sit down and listen and not necessarily draw your attention, or him, Domelevo, draw the other members of the committee's attention to anything at all? Does it come to you as a surprise?
No, because when they were there, we told them right from the beginning that this is a fact-finding committee. So it would be proper if they could find a counsel and let the counsel lead the witnesses, so that both parties, counsel for both parties, will now have the opportunity to cross-examine. They said no. They have adopted CI 147, which is adversarial. So for them, that's what they were going to do. So they had lawyers there, some of them who pretend to be commentators. One of them is Tadiosori. The other one is Tatutikata. They were those who wrote the petition, and they were those who were leading the witnesses to come and tell stories. And you will see Tadiosori writing and say, oh, a lawyer has said this. He was part of the whole thing, and he was sitting there. Tatutikata was the one who was leading the witnesses as if we were doing a case in court. Instead of asking maybe the committee itself to lead, and so we all ask questions so that the whole thing looks like fact-finding. It was clearly adversarial. That's what they did. We drew their attention. They said they will have none of that. We even told them to see if they can go under CI 65, like a committee of inquiry which has been set up, to use the procedures set up there. They said they will not do that. We told them that a committee of inquiry under the Constitution is the same as a commission of inquiry. So they can do that, use the CI. They said they will not use it.
Which means that it was their sole discretion to choose which one of the CIs they would operate under.
Yes, and so they said they have chosen CI 47. And even there, they have a right to make amendments to it by the chairperson of the committee orally. He can sit there and make amendment orally to it. This is what we went through.
Right, now that they chose the CI 47, this will mean that unfortunately they are unable to even comment on anything, especially what you thought Domelevo could have done. Because of the CI, did you not think that he felt that prohibition to at least advise the members?
No, you are sitting there and hearing evidence. If the law is that we should do a faithful and impartial investigation. So if you are faithful, and according to them, they were sworn in. Even we are saying that we saw no swearing in taking place. And so if they took oath to be truthful to their conscience and they are sitting there doing proper work, if they see anything wrong, wouldn't they have pointed out? Because either side, we could take objection, Tatuchikata could take objection. And on several occasions, we took objection against some documents they wanted to tender. They also took objection against some documents we wanted to tender, and then the committee ruled on it. That is that is how beautiful the whole thing looked like. Then when it came to addresses, having asked for time to file the addresses, they didn't wait for us, and then they went ahead and used the addresses filed by Tatuchikata and Tadiosori to determine this matter. So, for example,
you had no opportunity to file your address. All the addresses were filed by the petitions lawyers.
Yes, because the time we asked, as far as we are concerned, had not arrived, because they told us we could file it within a reasonable time. Even if we have missed the date they gave us, we could file it within a reasonable time. The day we were planning to go and file, or we had sent people to go and file, we saw it on television that they were presenting the report. Meanwhile, there were other 2 petitions pending, which they had adjourned to the 15th of September to hear. And yet they rushed that indecent haste. And in the morning, Domelevo having the guts to write "the strife is over, the battle is done" on his Facebook before going to present a report? Was this man truthful to himself? Was he doing an impartial investigation, or she saw the woman as a strife that she was fighting against, who must be removed? And that morning, the battle indeed had been done. This is the person we are talking about. I'm very, very annoyed with him, and I think his conduct is very shameful.
I mean, knowing that the procedure and the process is ended, the recommendation by the committee, the president is also bound by it. The application, the judicial review at the High Court by the former Chief Justice, will all of these your concerns find expression in there? Though I know what she's seeking a review on is not directly under this. In trying to mitigate how you feel, will this find expression in this review that she's applied for?
Of course, that is why we are going to court. And let me tell the whole public who are listening that up to today, we have not been served with the committee report and the recommendations. He is saying that he is surprised that the letter came from the Judicial Secretary. Ask him, apart from the revocation of the warrant, which was signed by His Excellency the President, go and ask him who notified the Chief Justice of a removal and the grounds for removal. It came from the Secretary to the President. The President did not communicate anything. In the same vein, that's what I'm telling you. He said he has revoked the warrant appointing a Chief Justice. Now, the reasons, whatever happened, was communicated to her through the Secretary to the President. Does he find that odd? Does he also find that odd? What is wrong? Is that a fake? Can we also say that it is fake because it was not signed by the President? This is public administration. And I think you have people there who should know something about public administration. Is that not the way things are done? You expect your warrant to include everything that the president wants to tell you. This will come later from other offices, and that will never make such a letter fake. And to have opened his mouth to have described that letter as fake leaves much to be desired. It's a disgrace.
Thank you so much for joining us this morning to bring some clarity to this conversation. Ni Ayikoi Otoo is the lead counsel for the former Chief Justice. I'd go to my other panelists and maybe take their comment on this. Hopefully they followed this discussion. Dr. Sasanti.
Yeah.
You have heard
Yes.
Ni Ayikoi Otoo this
I have
morning.
listened, but I have a few things to say. One, it is time now for us to look at Article 146 and look at it clearly, because the in-camera provision in there, that all these things must be done in camera, has been defeated through this process. When the issue started, letters were leaked, we read comments and all that. We saw people who were in that process, in camera, program, coming to tell us what happened in there. I find it a little surprising.
Especially on the side of a person who was part of the committee.
All of them.
I mean,
councils are out there, there telling us what happened in there. Members, you heard Domelevo out there telling us the letter was fake and all that. So I believe that that provision must be looked at, because it doesn't help anybody, the in-camera thing, because at the end of the day, I mean, everything is out. But for me, as I was listening to Mr. Ayikoi Otoo, what worries me is that you and I have no access to that letter, which Mr. Domelevo described as what, fake. So it will be very difficult for us to comment on that, because we have not seen the letter, the content and all that. We have listened to the two of them. It's worrying, because in democracy, transparency is key. So I believe that the crust of the matter is we looking at the 146 and trying to fine tune it so that all these things, look, we can have as the public can follow, because we pay those officers who occupy such office. And if we want to remove them, we are entitled to know what happens. And then all that. Look at lawyer Ayikoi Otoo saying that he has not even received the reports, of what transpired in terms of their ruling or the report that came out. He has not. And all that. We as a public, who finance, whoever be the Chief Justice and all that, we have no knowledge about it. That's unfair to us. And I believe that going forward, we as a state will have to look at these things so that it becomes something that we can assess. We can also follow the conversation and all that. But I don't know whether I heard Mr. Ayikoi Otoo well when he said that the petition were just written by Tadiosori and Mr. Chikata. If that is what he said, and I think it's unfortunate because does he have evidence that they wrote the petitions? Maybe I did not hear him well. So
well, luckily, though I released him, he's still with me just for him to put clarity. I do not think he meant the petitions itself. But lawyer Nico,
I meant the petitions themselves were written by them.
Right.
It is like going to court. If you are going to court, you ask a lawyer to write a claim for you. So your lawyers prepare the petition.
And that's not strange, is it?
Sorry.
No, is it strange?
That's not strange. I am saying that then you see Chachuchikata are trying to run away from it. But Tadiosori keeps writing things in the media as if he's just commenting as an ordinary lawyer. Meanwhile, he was in there and he was part of. In fact, these two lawyers are the lawyers for the first petitioner, Ofori, Daniel Ofori. They were the lawyers for Daniel Ofori in all the cases that he went to do in court. That's the point I'm making. I'm saying with all the emphasis at my command. Right. They wrote the petition for the man to sign.
Again, just for clarity, if usually a person would hire the services of a lawyer to write their claims or to write a petition, why is this one strange then? Just for clarity.
They then should not hide and create the impression that they are just public officers or people in the public who are commenting, especially Tadiosori. He wrote so many things about this trial. Meanwhile, he was inside. He was a member. I will give it to Chachuchikata. He never spoke about it. In fact, recently we were invited to TV3 for an anniversary of something they call Agenda. Earlier on, we were going to discuss that one. He said still he wanted to be out of it. He wanted them to drop that topic. So as for Chachuchikata, I will not say anything. But I'm saying that anything you have read during the hearing from Tadiosori, know that it was part of the whole scheme. They wrote the thing and they were there doing those things. They were their lawyers. And I'm saying that on authority.
Okay.
How would Daniel Ofori know what stated misbehavior are and what incompetence, what constitutes incompetence on their part? In fact, if you remember, the day that I came on Newsfile, one of the ladies from Asahi University said she was surprised at the amount of documentary evidence which came from the judiciary. Documentary evidence which came from the judiciary, including some of these things. Everybody had something from the judiciary to tender. How can we open ourselves that loose? For all documents there to be sent to Daniel Ofori, where did he get them from? Where did he get? If the Chief Justice traveled, who gave the information to Daniel Ofori to put it in a petition? If she was giving a per diem, who gave that information out? If there was an audit query, who gave that audit to Daniel Ofori?
Again, for some education, is this to suggest that this information is exclusive, it's not supposed to be in the public domain?
No, they were given to the judicial service. These are things, you have gone to do an audit, you saw something, you drew attention, and you gave the auditee opportunity to explain. The person explains, but like Dr. Asa said, before we went inside, this thing was already on everywhere on social media. That she was given $14,000, which she did not retire. When in fact, she retired it within 3 days that she returned to Ghana. That was why she went to the Supreme Court and said, I don't want this thing to happen in camera. Let us go out because we've already put everything out. Dr. Ansa, I'm telling you, this is what happened. They put everything out there. They leaked everything to the press. That was why she said no. Now I'm also coming out because people are vilifying me and attacking me at every stage when I have nobody to speak for me because they keep telling me that it is in camera. I'm also coming out to say
If the subject was not the core of the reason why the committee was set up to investigate, and this information has well found its way onto social media, will it be a worry? But for it being part of the investigative process, if we saw it on social media that the Chief Justice spends this amount of money in the travel and all of that, would it be a problem, especially from the audit?
Recently, the acting Chief Justice traveled to London. Have you heard anything about it? Do you know the per diem that he was giving? Do you know who he traveled with? Has it come to the public domain? Do you have evidence as a journalist, knowing how much he was given to travel? Is it proper for these things to be happening?
Why not? For example, this current Chief Justice, if the information is brought to the public, especially because it's the public funds, would it be a problem at all?
And I'm asking you, have you heard anything? Has it been brought to the public?
While I have not, the question really is if it finds its way.
That is not the way things are done. And again, this is something exclusive, and yet it came into the public domain and was used as a ground for removal even before the committee was set up. When we went there, it was already in the public domain. Ask Dr. Ansah whether he did not see those things. So where is he putting the blame? Okay. When before they came, they had already told us that they were coming to reset the judiciary, and that they cannot reset the judiciary with that Chief Justice sitting there. They had already said that.
Please stay with me. I'm happy that you have decided to stay with me, but I'll go back to Dr. Sasanti. And Solomon, I'll come to you right after Dr. Sasanti. Dr. Sasanti, you have some answers to your question. Of course, definitely people would have to hire the services of a lawyer, be it a petition, a claim, whatever it is. It's definitely not you that will be writing it, so I'm not surprised. But what triggered this question and your concern?
Yeah, I am also surprised that I want to find out from Ms. Ayikoi Otoo that is it wrong for Thaddeus Ory and to comment like any ordinary Ghanaian to comment on a matter that
no, I don't think he said that. He means that because he is a lawyer for one of the petitioners, this will mean that it defeats the whole purpose of us hearing everything in camera.
But the woman herself also was out there. Well, in a press conference.
Would it not be because the matter had already found its way onto social media and so defeats the whole in-camera purpose?
And he also talked about the fact that they were, before they started the issue, and I mean in the proceedings, they had documents, people had documents from the judicial service, all the documents. I mean, doesn't matter how they procure their evidence? Doesn't matter? I mean, whoever gave to them, the lawyers will go with it.
Dr. Ansah, I'm surprised now at the angle you are going, because I thought you said we should look at the entire in-camera thing.
No, but you were saying,
this is why
because you lawyers have been teaching us that it doesn't matter how people procure their evidence.
No, but I know the law. It doesn't matter. So long as we bring information. But I'm talking about the thing landing in the public before the committee starts the hearing.
That one, my position is still intact.
Yes,
I still maintain my position that all of you came out there talking about it, and I asked them, then what is the essence of we having that in-camera thing sitting in our books? That is my position.
And I'm saying that it was started by them. They leaked the petitions. They leaked the petitions to the public, including people like Taylor. So Calvin Taylor and the rest saying the woman must be jailed. And all those things were already out even before we went in. That's the point I'm making. So
Ms. Ayikoi Otoo, how sure are you to know that Mr. A or B leaked it? It's a problem. But if you are pinpointing people, then it becomes more problematic.
No, I am pinpointing Thaddeus Ory because he kept writing about the ongoings of the committee when people did not know that he was one of the lawyers for Daniel Domelevo, the only petition that we dealt with. That's why I brought that one in. That's why I brought it in. Anybody can comment if he wants to comment. But if we are talking about the in-camera, and you are a member, if you look, ask the journalist whether I opened my mouth. It was after the recommendations were made that I came out to speak. I never spoke throughout because I wanted to be truthful to the in-camera. And I even refused to be present at the press conference. I said, I will not go there. So please, listen to me carefully. What I'm saying is that they put the thing out there in public. The woman felt that she was suffocating because people were saying all sorts of things against her. I am also going to the public to tell the public my side of the story.
Yeah, I think lawyer Ayikoi Otoo is a lawyer. He knows what to do. So if something went wrong, he knows what to do. So I'll leave it with
Thank
him.
you very much.
Okay. Sulemana, if you're still with me, I'm certain that you'll follow the conversation. I'd like to hear from you.
Well, thank you very much. I think we are dealing here with two respected persons. Lawyer Ayikoi Otoo is a very, very respected senior citizen. Undoubtedly, Mr. Daniel Domelevo is also a very respected person in this country. I think sometimes we, those in the media, don't help matters. The people and the public look up to us to provide independent information, independent evidence when things turn this way. And I think that it is not late. It is important that the public get to know the full facts. The documents may not be available, but you know, as journalists, we have how we get our information.
Right.
Sanctity has been a journalist before. And, you know, all the work that we do, certainly we have sources, people will leak things to us and all of that. And people have their interest in why they give out information. So in terms of that, of course, if people had grudges with whoever they wanted, they would leak information. I think the unfortunate thing is that sometimes some of these things turn political, even if it's a matter of national interest. The conversations, the debates, and the analysis of it turns political. Not surprisingly, all the matters relating to the Chief Justice, the petition, and all the debates that surrounded it eventually turned quite political. MPP versus NDC and so on. And in the course of that, we lose as a country. We don't get to have the full facts. You know, we don't get to know what the realities are. But like I said, it is not late, because removing a Chief Justice is a critical matter. So if it has already happened, we as journalists must dig deeper to bring the evidence to the public, so that if the right thing was done, the public would know. If the wrong thing was done, the public will know. Now, from what lawyer Ayikoi Otoo has said, maybe the use of the word fake, and of course we can engage Mr. Domelevo to have further details about that. Maybe the use of the word fake could be what is wrong, because fake means the thing is really non-existent. It's a creation by someone to deceive and so on. But maybe if it was to say it was an illegitimate document, to say that, yes, it's not a fake document, but it is not a document that carries the weight to turn whatever evidence that we have, or the person who authored it didn't have the authority to do so, or in my view, that is not the right person to have done that. I think that could have been maybe the appropriate language, rather than calling it fake. Fake means it doesn't exist. You just go and create something to come and deceive. Right. But like I said, we may have to go into it to know the full
interrogate
details.
The use of the fake, the word use of fake particularly, maybe.
Yes. All right. So that would be my point. I think that the public need to know the full facts of the matter, and as journalists, we have a responsibility to let the public have neutral, independent perspectives to issues, so that they can be properly informed. But at this stage, we are basically feeding the public with what this side is saying and what that side is saying.
Right.
And you say, well, they should judge for themselves. But where is the evidence that we are putting forward, so that the public can be helped to make a judgment for themselves?
Thank you, Sulemana. I'd go to Dr. Osei Kwapon. If you follow the conversation between yesterday and this morning, what would you say? I've also heard many people say that for an auditor and then for a lawyer, if the auditor uses the word fake, he may probably mean something entirely different. But of course, a lawyer will take it as it means legally. How do you feel about this particularly?
But even if a lawyer and an auditor would give different interpretations to the word fake. Given the nature of this removal process, how contentious it became and how political it became, to the ordinary person in the public domain following this, it is a very serious thing to put out in the public domain and accuse the lead counsel for the Chief Justice of providing something fake before the committee. That, for me, is quite a serious, in my opinion, slur to cast on the image, of someone who is leading, the Chief Justice, right? Regardless of the meaning or the context it was being used. I, as a member of the public, my first reaction is, this is serious, right? And if it is not, then you can only imagine what you create in the minds of the public over a process that has already been very contentious and has become extremely critical. I would have expected, with all due respect, that Mr. Domelevo would have been a bit more restrained in whatever, even if he felt that the Honorable Ayikoi Otoo had said something that displeased him, that he would have still been a bit more restrained in his choice of language to describe whatever. But beyond that, it also, for me, brings into question the sanctity of the process. If you're going to remove the highest officer of your judiciary, right? You can't have the process lose that sacrosanct aspect of it if it is going to degenerate into public commentary by those involved in the process.
Yeah.
And maybe as we rethink 146 and as we rethink the rules that guides this process in the future, that perhaps one of the things we need to make clear is that when it is over, even if it is 100 years later, those who participated in it are still barred from talking about it, right? Because again, I'm sure the framers of the Constitution had good reason for why they wanted this to be in camera. But if, when it's over, you're going to go into the public domain and say all manner of things about it to stir further controversy about an already controversial process, then it loses its sanctity. And I think we have to sort of get back to a place where we can protect the sanctity of some of these critical institutional processes.
Right. Thank you so much. I'll probably give the last few seconds to Ne Ayikoi Otoo, the lead counsel for the former Chief Justice, if you're still with us.
Yes, I would reiterate what I said, that is very disgraceful on his part, that being a very highly respected official in this country, he should have restrained himself when he decided to go to that tangent, even saying that he was saying so with the emphasis at his command that we produce fake documents and all that. I mean, if you have tried to taint the person at black already, and the thing had already happened, why do you go on? I mean, why are you flocking a dead horse? You have even succeeded in removing her. Now give us the report. You have failed to give us the report till today. So this might be some of the things they smuggled into it, that she brought a fake letter. When you did not understand the public processes, how can you say that the letter is fake because you expected it to be in the warrant signed by the president? So since the president did not sign that letter, therefore the entire thing is fake. I have been appointed twice, and in all these matters, I didn't get my conditions of service from the president. I got it from other officers.
Finally,
so he should come back again.
Finally,
the best thing is for him to just apologize for this ignorance and this thing that he has done. He should just apologize to the public.
Finally, before I let you go, the Attorney General has said that the judicial review, which you're seeking at the High Court lacks a jurisdiction because it falls under Article 146 and that it should be the Supreme Court. Are you considering this or you're proceeding?
No, we have seen a process filed by them asking that the matter should be referred to the Supreme Court for interpretation. That is the position for now. So let's go to the High Court and see whether the High Court will want to refer the matter to the Supreme Court.
Okay, we haven't had anything quite recently, especially about your journey to ECOWAS Court. You want to give us an update on that as well?
You know, courts go on vacation, so they were also on vacation.
Okay.
Now that they have come up, we'll see what will happen. If they have not done all these things with indecent haste, only to stop them from coming out with a full ruling. Very disgraceful, another one on the part of government. You know that we are in an international court and we have put interim measures there, which they are going to rule upon. And then you quickly relied on only one of the petitions to say you have removed it. The two are still pending, even when cases were also pending before the Supreme Court. Right.
Lawyer Ni Ayikoi Otoo, thank you so much for joining us this morning.
Thank you for having me. Thank you for having me.
And as well, Dr. Asante, thank you as well for joining us on the news review this morning. Suleiman Abrahima, thank you so much for joining us this morning. And as well, Dr. Osai Kwapon as well, thank you for joining us on news review this morning.